Here are two things you should never, ever do in a pretrial question and answer session known as a deposition. You want to know what this is all about? Come join me for a walk through the neighborhood as I share with you exactly what this is about. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. During the course of a lawsuit, whether it's a medical malpractice case, whether it's an accident case, or even a wrongful death case, during the course of your lawsuit, you will need to be asked questions by the defense attorney in a process called a pretrial deposition. Lawyers also call it an examination before trial. In pre-COVID times, this would take place in your attorney's office. In post-COVID times, this typically will take place on a Zoom video call. Now, you might be thinking, okay, this is kind of informal and it doesn't really make much of a difference as to how you answer the questions. Well, nothing could be further from the truth. In reality, the answers that you give to these questions are recorded, and they're recorded by a court stenographer who records all of the questions you are asked as well as all of the answers that you give. The answers that you give represent your sworn testimony, and it carries the same exact weight as if you are testifying in court, at trial, in front of a judge and in front of a jury. So don't think for a second that just because you are answering questions by a defense attorney on a Zoom video call, and you might be doing it from the comfort of your own home in a relaxed setting, that this does not have a significant effect on your particular case. Just the opposite. Your answers carry the same exact weight as if you are testifying in court. So now let's get back to the question I just raised in the title of this video. What are the two things you should never, ever do during the course of this deposition? The very first thing is never keep talking if your attorney says objection. That's number one. Now, before I go on to number two, let me explain. When an attorney yells out objection, it means that he thinks that there's a problem with the question that you are being asked. There could be many different problems. Maybe the question is not phrased properly. Maybe it contains two questions within one, and by answering that question, somebody reading it later on won't know whether the answer you gave was for the first part or for the second part. That's called a compound question, where you have two questions built into one. As an example, it might be, okay, Mr. Jones, on January 5th, isn't it true that you were standing at the corner of Main Street and First Avenue and it was 75 degrees outside? Objection. If he says yes, what's he saying yes to? That it was 75 degrees outside, or that he's standing on the corner? So that's a problem. Maybe there's a problem with the topic that you are being asked. There could be many, many different reasons. Maybe it's something that should not be discussed during the course of a deposition, something that's off limits. Maybe there's a legal basis, and hopefully there's a legal basis and a reason to raise such an objection. So the one thing you should never ever do is to continue giving your answer when your attorney yells out, objection! When an attorney does that, the best thing that you can do as the witness who is being questioned in this pretrial process is to wait a moment. And now the attorneys will have a brief discussion about whether or not you have to answer the question. In many instances, even though the attorney has raised an objection and voiced the objection and articulated the reason for that objection, at least in New York, the attorney will probably tell you to go ahead and answer the question anyway. And there are many reasons for that to occur. So pay close attention to what your attorney tells you following his objection. So what's the second thing you should never do? The second thing you should never do is play word games with the defense attorney. Now, what do I mean? Some witnesses think that they can outsmart the defense attorney. Some witnesses think that by being cute and playing semantics, now they can go ahead and confuse the defense lawyer. They think they can go ahead and turn a question favorably simply by asking questions or by playing word games. So now it's going to frustrate the attorney. And the reason why I tell you that will not work, and that is not a great suggestion, is because the defense attorney is going to get upset, the defense attorney is going to get frustrated, and in all likelihood, the defense lawyer is going to start getting somewhat aggressive with the questions. Why? Because the defense attorney will know what you're trying to do. He'll know that you're trying to screw around with him. He'll know that you're trying to distract him. And you know what? Something like that happens to the defense lawyer, he's going to dig his heels in and he's going to go after it until you actually answer his question. And it could be something so simple. Something as simple as saying, Mr. Jones, isn't it true that you were at this location at this time? And instead of being precise and answering yes or no, you turn around and say, well, I was near there, but I wasn't exactly there, but I was over here, and 5 minutes earlier I was someplace else. The question was, isn't it true that at this point in time you were over here? Instead of saying yes or no, you now give some long-winded answer that doesn't directly answer that question. If you keep trying to avoid a direct answer to his question and now give evasive answers and play cutesy word games, he's going to dig his heels in, and it does not look favorably for you. You know, one of the things that occurs during the course of a deposition is that the defense attorney walks away with an impression of you. And they take that impression and they report that back to the insurance company. And why do they do that? Because not only are they looking to see whether you have certain information about what occurred to you in your own words and what problems you have today, but the defense also wants to know what type of witness you are going to make at the time of trial. And the defense attorney turns around and says, listen, if this witness is giving me such a hard time during this informal pretrial deposition, just think at what will happen at the time of trial. If he does this in front of a judge and in front of a jury, we don't think that the jury will appreciate it. We think the jury will actually get angry, and now it's going to backfire on him, this particular strategy. So it's critically important that you understand that the defense is not only just asking you questions about what happened factually, but they are forming in their own mind a mental impression of what type of witness you are going to be when your case goes to trial. And that plays a significant factor in their evaluation of whether or not to settle your case. And if they come to the conclusion that they are interested in trying to settle and negotiate your case, guess what? The impression that they think you are going to make in front of a judge or a jury will play a factor in the negotiations that you encounter, or at least that your attorney encounters. So why do I share these two things about things you should never do during a pretrial deposition? I share it with you just to open your eyes to help you understand how these types of cases work in the state of New York. You know, I recognize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.